to my left, to your right, we have Dane Littlefield, who is a third-year law student at McGeorge, and he is the chief symposium editor for the Pacific McGeorge Global Business and Development Law Journal. He's also a member of the McGeorge Sustainability Committee and the Space Law Society. So both, the natural resources and space panels, really things he endorsed. He was also a member of the planning team, which met several times to talk about this program, and so really appreciate his input. And then, let me just stand over here so I'm not blocking. I think everyone knows that this is distinguished professor of law, John Sprankling. John began his legal career with Miller, Starr & Regalia, one of the nation's largest property law firms. He practiced there for 14 years and ultimately served as its managing partner. He's taught at UC Hastings and Stanford, and then joined the Pacific McGeorge faculty. Here at McGeorge, he served as interim dean, and he was the associate dean for academic affairs when I began my career here as well. He's been a great mentor to me in learning to teach property and in becoming a scholar. Of course, John is an internationally recognized author on property law, the author of 6 books on this subject, and we are here celebrating his most recent book, The International Law of Property, and I will let Dane take it away from there.
First, I'd just like to ask some general background questions, Professor Sprankling. What inspired you to write your book on international property law?
You know, I was doing the book with Matthew and Ray Collette, who just retired, called Global Issues in Property Law. And really, Frank Gewirtz was the inspiration for this series through West. And the concept was, let's introduce international comparative law concepts in first-year courses in American law schools to expose even beginning students to the international dimension. And so Frank talked to me about doing the property book, and I talked to Matthew and Ray, and we did it together. And as we were going through that book, which mainly was comparative law, we had some international law on the rights of indigenous peoples, particularly some decisions from the Inter-American Court of Human Rights, which are really quite interesting. It started with me thinking, because, of course, we have a lot of international connections here at McGeorge, and Claude and Steve over there have been huge inspirations for all of us in the international arena, trying to think, what is the international dimension to your subject? And I really started thinking about, is there such a thing as an international property law? In other words, if you look at international law through a property lens, is there anything? And I started finding bits and pieces and ultimately kind of strung them together and said, there's a lot here, there's more than I thought. So it really goes back to trying to come up with a textbook for American law students. What is the content? Is there anything other than comparative law? And we put some great stuff in there. It was really exciting. But that started my thinking, kind of this journey to see, is there an international law of property? And the convention was no, and I think that wisdom is wrong. Yeah.
What first interested you in property law as a subject generally?
Part of this is just purely accidental. In my first year of law school, my highest grade was in property. So this created the illusion I knew something about the subject, and as you know, that's really not at all true. My property professor is a great guy, Mike Heyman, who later became the head of the Smithsonian in D.C., and he taught a land use course, basically. So I never actually learned property at all. But for many of us, property is the world of the tangible. And certainly for land or other tangible objects, there's always been a great, it's real, you can see it. So working with clients, in particular when I was a real lawyer on real property deals, land evokes a very visceral response in many people, and so it transcends the rational. Landowners are not rational maximizers often. They have very different approaches to their assets.
Well, speaking of your time as a real lawyer, what inspired you to move from that career into academia?
Both my parents were teachers, and so that's always been attractive to me. After a year of practice, I realized one of my fellow attorneys, a more senior attorney, was teaching in Hastings, writing research. And I said to her, can you get me in? And she said, well, yeah, I think so. So I started teaching at Hastings. It was great. And that ultimately blossomed into a year at Stanford, which was terrific. in particular because at Stanford I got to study with John Merriman, and if you know anything about comparative property law, John Merriman is really a demagogue. It's the highest praise we can offer today in that world. He's a guy who started, I think, really as a property guy, became a comparative scholar, and then became an expert in international art law. And of course, the art people think he's a law guy. The law people think he's an art guy. He kind of straddles two worlds. But an amazing and inspirational thinker about, in particular, comparative property law in the civil and common law systems. And of course, they just took off from there.
Oh, well, after teaching at 3 different colleges, different law schools, I'm just kind of wondering, what do you enjoy the most about teaching?
I think all professors would say what we enjoy most are working with the students. And we did not come to academia because of the big paychecks. So if you're thinking about big paychecks, that's private practice. I joked that in my first year here I made less than I used to pay in taxes when I was a lawyer. So the pay cut is huge. But the psychic income is terrific. So we're here because we enjoy working with young people. And the other part, of course, is as an attorney, you have to represent the clients you get. And one can't always choose the clients you have. And so as an attorney, my voice and my pen were for hire. You could hire me. I had to write and say what people wanted me to write and say, but as a scholar, I have a lot more freedom. And that's, of course, very liberating. So that's something that draws people, obviously, to the academy.
Moving into the substantive topics in your book, I was wondering if first you could give just a description of the sources of law that you drew upon when you were drafting an international definition of property.
It's really interesting because when you think about international property law, people, I think, would first start thinking about direct expropriation, as Jared was saying. And when you think about anything other than direct expropriation, when you think about, for example, indirect expropriation or full protection and security, fair and equitable treatment, the question becomes, well, whose law are we going to apply to determine the content of those rights? We had, certainly in the early 1900s, the notion of the international minimum standard for foreign investment, whatever that meant. But there was a concept that there was an international minimum standard of protection that transcended national law, right? It had to be defined by some non-national standard because otherwise a state could eviscerate the protection just by changing its domestic law, right? So if expropriation is to have any content, it must be governed by a standard which is not based in domestic law. There has to be some external international standard. And so when you start thinking about that, then I think all the expropriation cases from different tribunals, and particularly more recently all the arbitral tribunals that people have talked about in connection with the multilateral and bilateral trade agreements, we're looking at 40 to 50 decisions almost a year, which have some property component to them, in which ad hoc tribunals are trying to kind of figure out how the law of property should apply, and a lot of those decisions, I think, are pretty inconsistent. But you do see kind of a developing common law, I think, of property in the international investment world, as Jared was saying in particular about the rights we've traditionally seen in the bundle. But the international human rights decisions we've talked about today, the European Court of Human Rights has more than 1,000 property decisions. The Inter-American Court, particularly in the area of Aboriginal rights, as Thomas and others were saying, terrific. The African Commission has about 20, 25 property decisions, and now, of course, the new African Court is superseding the Commission. More than 2/3 of the world's nations are parties to human rights conventions which recognize the right to property. So I kind of start with that. More than 2/3 of the nations recognize by treaty a human right to property. And there was the question was well asked about, well, are these different tribunals interpreting the human right to property the same way? And I think the answer was, well, given that to some extent they are. In particular, you've seen the Inter-American Court on Aboriginal people's rights being cited by the African Commission. Really interesting transference there. And the Inter-American Court relying to some extent on the European Court of Human Rights. So there's a huge body of case law, which of course as common law lawyers we love. We love case law. And those kind of started me off. So my research assistants and I read every single reported decisions from the European Court of Human Rights on property. And if you've read those decisions, they're not short. The European Court likes long decisions. Although, intriguingly, when the court has considered the same issue over again, it has a tendency in recent decisions to say, we've already decided this, citation. And to a common law lawyer, it almost sounds like precedent. No, we can't call it precedent, just influential, it's persuasive. But there, so many sources. Obviously, there's a lot of soft law out there. You could spend your life just thinking about how the UN is dealing with property rights and all the different agencies, which have so many different guidelines and reports and instruments and so forth. Not to mention all the treaties and all the arbitral decisions and the investment side, the human rights side. There's just a lot.
Among those sources, I was wondering how human rights treaties have influenced property rights in that definition, or just or property rights in general, the human rights of property.
I mean, the part of the question that I talk about in the book is, if we premise an international right to property on the human right to property, what are the consequences of that decision? For example, how is the human right to property different from a right to property generally? And there are some differences. We generally don't view the human right to property in economic terms. It's a personal right. And therefore the question becomes, what do we sacrifice? For example, under many human rights schemes, an entity doesn't have a human right to property. Some do, some don't, depending on the treaty. And so if we're interested in international right to property, it has to be more than a right of an individual, right, which is what human rights, of course, focus on. So there's some trade-offs in terms of how we define the scope of the right. But what's nice about the human rights treaties, at least for my work, was so many nations divide into them. And if you're trying to establish, as I do in part of the book, the notion that is there an internationally recognized right to property, or is it simply a product of domestic law? To the extent I argue that there is, and part of the source is conventional law, we have to look at it, conventional law, say, do we have any treaties in which nations have recognized this? And the human rights treaties, again, 2/3 of UN members have signed those treaties. That's a pretty good consensus. Beyond that, when you look at, what are some other treaties that recognize the right to property internationally, arguably, setting aside General Assembly resolutions and soft law, there are some anti-discrimination treaties that seem to implicitly recognize the right to property exists. At least I think that's a colorable argument. In the treaties involving discrimination against women, migrant workers, and the handicapped and so forth. And most of the other 1/3 of the world that hasn't ratified a human rights treaty, like the United States, have ratified the anti-discrimination treaties. So there's kind of a conventional law argument, but it really hinges mainly on the human rights treaties. And of course, the investment treaties are helpful, but I think more scattered.
As a sort of example of how private property rights are able to evolve and emerge, I was wondering if you could describe how they did re-emerge and begin to evolve in post-Soviet states after the fall of the Soviet Union as a more contemporary example of the creation of private property rights.
It's so interesting. The Soviets, initially after 1917, were very strict in abolishing private property. They abolished inheritance, for example. And that lasted, I think, 4 years. They brought back inheritance. But they really narrowed the scope of property, as we all know, in a socialist state, which could be considered a subject to private ownership. With the new Eastern European states emerging, when you look at what they did, they immediately bring back the right of inheritance, and they enshrine it typically in the Constitution. They bring back a broad right to property, which is not limited to household or personal property. And it's almost a rebellion of joy against the former Soviet model. And China. Frank Wong is in the audience, and he and his wife Laura are very helpful in helping me learn a little bit about the law of China and having a chance to travel there and teach. And when you look at, China, if you haven't been to China yet, go. Because the notion that you would view China as a communist system, it's truly obsolete. There's a brand of capitalism there which is extraordinarily vibrant. It's kind of reminiscent of the Gilded Age here, with perhaps less governmental controls in some way than we have here. And it's easy to say that China is probably more capitalist in that sense than we are in a way. And here's what we know about market economies. if you want to move to a market economy, you have to recognize a robust system of private property rights. Otherwise, it doesn't work. And so as the Eastern European states move to a market economy, and even if you look at the developments after the kind of anti-colonial rhetoric of developing countries in the 60s and 70s, as those countries began to be much more interested in attracting foreign capital, they began to be much more friendly to foreign investment and much more protective of property rights. And so the shift after the fall of the Soviet Union, the fall of the Berlin Wall, to kind of a new era, when you look around and say, well, who's against private property rights? I mean, where's the ideological split anymore in the post-Cold War world? You look at countries like North Korea, Zimbabwe, Venezuela for a while. Countries like that, it's a very small universe. And so we've had this victory of market systems and private property rights, which it hasn't quite swept all 193 UN member nations, but most. And it raises the questions we talked about a little bit so far this morning about, well, you know, what does this mean and what are the perils? Because the title of today's discussion is, I think, well phrased. They're promises, but they're perils. There are some truly negative aspects we can think about as we imagine a Western-style system of strong private property rights in terms of the potential impact on indigenous and tribal peoples, in terms of the impact on land redistribution in a country like South Africa, as you think about the fight of the war against poverty in some nations in particular. So this is not entirely rosy, but I think you'd have to say, looking around the world, market economies predominate. The trend is certainly moving in that direction. We look at Russia, you know, not a free market economy perhaps, with a lot of crony capitalism and the like, but certainly perhaps a little more capitalistic than it was some years ago. So I think that the trend is on the right side of history. The trend is toward enhanced private property rights. And then the question, of course, becomes, okay, if virtually every nation state recognizes a robust system of private property rights, and we have disputes at the international level between a state and an individual, would an international tribunal not recognize that there is something called an international right to property? And of course, we've seen this play out, of course, in the formats we talked about so far this morning. Individual versus state in a human rights case, individual versus state in an investment case. We didn't have these kind of disputes 50 years ago in any great degree. As Jared and others have pointed out, we viewed expropriation as an offense against the state, not a justiciable claim of a private individual.
Well, as we all learned in our first year property course, the right to exclude from property is one of the core aspects of the bundle of rights. And I was curious if you could explain whether there are any effective models for recording and tracking property rights at the global levels in order to help people keep title in order to have an authority behind excluding others from their property.
Yeah, I mean, there's promise here and there's peril. And this kind of goes to what we call registration systems. And the leading example, of course, is under the Cape Town Convention, which deals with security interests in aircraft and aircraft parts. So arriving out of Cape Town, we have a convention which creates an international system of security interests in aircraft and aircraft parts. And it's all operated electronically, remotely via the internet out of Ireland. So if you're any place in the world and you're going to finance aircraft acquisition, you're going to have a security interest which arises under the Cape Town Convention and which is recorded electronically in this registry in Ireland. And we've expanded that to include contracts of sale. So when you look at that as a model, suddenly you have a registry of property rights, very much like the civil law system, created under international law, which is the world model. And of course, growing from Cape Town, we've negotiated a very similar arrangement for train equipment, not yet in place, and one for space assets, because of course, if we're financing satellites, we want to have security interests which are enforceable in all jurisdictions. So this notion of registries is very powerful. Historically, we see ship mortgages. Ship mortgages, folks. The maritime law is in many ways the birth of these security interests, but the system for ship mortgages is not nearly as robust as the Cape Town system for aircraft, trains, or space assets. But we have registration systems elsewhere. But the concept that you have some kind of international body which is in charge of recognizing property rights and to some extent delineating property rights, that's really revolutionary. Because historically, as you know, property rights have been tied to sovereignty. They've been tied to control over sovereign territory because the property historically was land. And if you don't have control over your sovereign land through property rights in your state, you're not a state, arguably. But today, with borders becoming less important, as transactions increasingly happening over the internet, as we have forms of digital property, as we have enhanced international trade, this whole model of the sanctity of national borders is just so much less important over time. And thus, we have enhanced need for something more, something different. And the registries are certainly a start. Now, that's scary at the same time, because if suddenly property rights are going to be determined by some international registry in some other country far away with limited recourse in national courts, the perils could be substantial.
And speaking of, say, foreign courts, I was wondering, following up on that, what mechanisms or systems do you think would be the most effective for adjudicating international property disputes?
Yeah, you know, the famous saying is that most nations obey international law because it's in their interest to do so, even though, or do so 95% of the time, even though it's difficult to compel. You know, we have the regional human rights tribunals, which are very, very useful in rendering decisions, and a track record of many countries following their dictates. Russia has not been great, by the way, at following the decisions of the European Court of Human Rights. They've done some. Some other nations have. Even in the Inter-American system, we've had some nations exactly not willing to comply with the decisions of the Inter-American Court. So the judicial model is a tough one, no question about that. On the intellectual property side, of course, as I hope we'll hear a little bit more of this afternoon, you know, there we have a robust enforcement mechanism, arguably, and it's the WTO dispute resolution system. Because once you take international property rights through TRIPS and you make them part of the WTO, right, a nation that does not effectively provide an enforcement mechanism can be subject to trade sanctions, and those are extraordinarily powerful. So, you know, we actually have in the WTO model a very potent weapon for enforcement. It may be too potent, maybe the problem. But the distance between that kind of model, in effect, a world arbitral decision with authority to enforce its decisions, and the rather weak tribunal models of international courts of human rights, there's a lot of gap. Ultimately, though, it's going to be very, very difficult to enforce this kind of system, except in small arenas, and nothing narrow arenas, other than through self-interest. I mean, aircraft financing is a good example. Not that many players in the market. They have a self-interest in perpetuating the system, and therefore self-interest to some extent in self-policing.
Building off of the previous panel, I was wondering what your opinion was to what degree the increased priority that we give to sustainability of natural resources in Western culture will affect international cultural norms in natural resource acquisition and use? Yeah,
it's a really good question because, of course, there's a lot of what's traditionally been called international environmental law, which I would argue is actually international land use law. And if you kind of, and part of that is because to the Soviets, right, property was anathema. And so when you look at what happened to the right to property in the Universal Declaration, right, look at the French Declaration of Man and the Citizen, 1789. Article 17 creates the right to property, and it's identified as one of the 4 sacred rights of humanity by the French in 1789. When you look at the Universal Declaration of Human Rights in 1948, where is the right to property? Article 17. It's exactly the same article as in the French Declaration of 1789. It's homage to the French, or maybe the French ordered it that way, right? And so, I mean, but then when you look at what happened, right, the concept behind the Declaration was that those rights were going to be placed in a binding treaty. The Declaration was step 1. The treaty was step 2. If you look at the Declaration of Human Rights, which rights aren't in the covenants? The answer, there's really only one, it's the right to property, because it was too controversial. Another issue that I've been seeing come up throughout the panels is that
there are negative aspects of recognizing an international law of property, and I was wondering if you could speak to those a bit as to who could be negatively affected by recognizing.
Yeah, this is the peril side, and I think different people have touched on this, and it's quite real. The principal concern, I think, as a panel member noted, was that the law of property in this sphere is really premised on a Western notion of strong individual property rights. And that's a notion that does not fit all cultures, as we know. So there's some risks. One, obviously, is the impact on indigenous and tribal peoples. And as one of the morning panels talked about, we've tried to mitigate that impact by recognizing communal property rights, which is a wonderful approach. The difficulty, I guess, I would pose to the group is that's kind of a static model. If we look at the evolution of cultures and societies over time, what happens when some members of an indigenous group are no longer happy with communal rights? What happens if we place so much focus on individual kind of Western style rights that they begin saying, you know, we want Western style rights? What happens to that group? Can they maintain their cultural cohesiveness? Would this kind of dual system undercut these traditional cultures? I think those are great issues. Poverty. I mean, let's be realistic, folks. We do not live in poverty, but billions of people do. How do we combat poverty with a robust system of Western-style property rights? In particular, beyond the work of Hernando de Soto and other economists who've said that property rights can be very valuable for people bringing them out of poverty. Part of the dark side, of course, is something like land redistribution. So if we're in South Africa and we want to redistribute land after the death of apartheid, and we're going to take it from white settlers and give it to the majority black population, how do we do that if we protected the rights of those white owners with strong international property rights? South Africa dealt with this as it tried to reconstitute its new convention, and I think tried with some success to bridge that divide. But it's a tough question, right? Because land is a zero-sum game. There's only so much. If we're going to give it to this part of the room, we have to take it from this part of the room. And if we recognize your strong property rights and we have to pay full value to expropriate the property, we're never going to have the government resources to do it. So perils is the issue. There are some problems here, and one should not underestimate the problems.
What issues did not make it into the book, but could be ripe for a second edition? And and building off that, what do you think are the most interesting emerging issues in property that are coming up on the horizon?
Yeah, you know, I was telling someone at the break that my colleague, Professor Glenn, and I have a textbook out on property law, which has been actually purchased at a number of schools. That's in use now, I think, at 50 law schools in the U.S. And those books actually sell. This book actually doesn't sell. What it does is it sits on library shelves under domestic law, apparently. Fortunately, actually, Oxford scholarship is up online. And so this book, and I think 3,000 other Oxford books, are available electronically through our library and many others. And that's probably the best way that the book is ever going to get to anyone, because if you search in that database of online Oxford legal scholarship, and you'll put in any property terms, the book comes up high, because there's not much out there on this subject. So one would love to think there's going to be a second edition. You know, one area I did almost nothing on was ad hoc tribunals dealing with property rights. And we know in areas like Kosovo, for example, the Iran U.S. Claims Tribunal being another example, Bosnia-Herzegovina, there have been specialized tribunals dealing with property rights issues, and there's a lot of interesting law there. The arbitral decisions from investment, bilateral, multilateral investment treaties, you know, those are coming hot and heavy, and people are looking at those, but that's a huge reservoir for potential scholars thinking about how is that investment law developing, and the volume of those filings is just increasing exponentially, and I would say that not enough attention has been paid to what those courts are trying to do to think about property, and it goes back to the need. If we're going to have any kind of consistency and coherence, and I think people refer to this in the morning, you know, why say property should be a separate field at the international level? What's the value in that? And I think there's some jurisprudential value and some practical value. And part of it goes to the point that Matthew was making about legal categories. I mean, how do legal categories change? Lawyers view the law through categories. That's how we're trained. In the first year of American law school, we introduced students to a box called contracts, there's a box called torts, there's a box called property. But we know the boundaries are artificial, right? The law, as Holmes supposedly said, is a seamless web. But for purposes of development, clarity, legitimacy, consistency, we divide the law into categories. And at the international level, one of the concerns, I think, has been we may not have enough categories. Certainly the International Law Commission has expressed concern about the fragmentation of international law. The notion being there are too many pieces floating around and they haven't coalesced. Because once you coalesce, then you can start looking for commonalities. As Matthew was saying, if you bring the anomalies together, suddenly it's a collection of anomalies and therefore they're not anomalous anymore, right? It's the beginning of a genre. We've certainly seen that, for example, in the area of international environmental law. Fascinating. How many decades ago it didn't exist, and then all of a sudden it's here. International criminal law. Well, you think before Nuremberg, did we have a lot of international criminal law? International contract law. Think back on, go back enough decades before the CIHD, do we have international contract law? So, to some extent, what we're looking at is the movement of traditional domestic law subjects to the international arena, as we move away from the notion that the nation state is the only actor in international law. And once that happens, we're kind of exploring these new fields. So the short answer is there are going to be a lot of developments here very quickly in what I think of as a discrete subject, and the need for lots of scholars to keep up with what's going on. Just in the Inter-American Court alone, as Thomas was pointing out, the huge volume of property case law going on. And just in Africa, nobody's worked, I think, to my knowledge, on the African property human in Africa in any depth. And even the European Court of Human Rights, only 2 books on property rights in the European Court of Human Rights. So there's huge opportunities. So the future, well, of course, space law we all love. I taught a course here in space law last year in response to student demand, and some of the students found out about it. Some were here, and Joe and the others in the back. And they circulated a petition to have it taught next year. 56 students signed up to teach space law. It's not normally something we would offer. So it's a very exciting area. And as you think about the final frontier, this takes us really to the global commons. And Rachel and others have talked about this, but property law as a domestic subject assumes sovereignty. And we increasingly know we have these areas called the global commons that no one has sovereignty over. And they are the high seas. They are Antarctica, fascinating issues in Antarctica. They are the center of the Earth, in my view. Maybe the cyberspace, interesting issue, certainly outer space. And we need some kind of system to deal with property rights in those realms. The model we have so far is the ocean model. So if Rachel's vessel goes sailing across the high seas and she's a French national, what happens in the vessel is governed by French law. And that works really well for a simple model where the vessel leaves a French port and returns to a French port. But when you try to export that model to the global commons generally, space being an example, and you think about an era in which we don't have a space vehicle which is only occupied by one nation or the product of one nation, but you have multiple nations involved, or some kind of territorial base on some kind of a celestial body where you don't have just one nation, multiple nations, this question of conflict of laws, whose law is going to apply, is a huge problem. And then the question arises, might we not need some kind of more consistent legal principles, at least at a minimum? And I guess part of my pitch here is one way to handle the issue of consistent international standards and create at the same time some level of national autonomy is to adopt the approach of the International Human Rights Treaties, of the investment law as well, and TRIPS, and be thinking about international minimum standards of protection. So when you look at TRIPS, for example, on intellectual property, each nation under TRIPS must provide at least as much copyright protection as TRIPS and therefore Berne require. But a nation can provide more. In the same way human rights, a nation can provide more protection for property than the international minimum. Or an investment, whatever the international minimum standard of protection is, a state can do more. And so this notion of a floor, kind of minimum standards, with the ability of a state to do something different above and beyond that, I find just very appealing. And maybe that's kind of where we're going. But back to the global comments, I hope you all stay for the space law stuff, because that promises to be really interesting. You know, what are we going to do, ladies and gentlemen, when robot ships start landing on the moon and mining helium-3 or some other valuable product? What's going to happen? Who's going to complain? Is there going to be a claim that those minerals aren't owned? When they're brought back to Earth, can they be sold in international transit? Is someone going to grab them and say, well, you expropriated this in violation of the Outer Space Treaty of 1967, therefore we're going to impound this? These are fascinating questions, to which I'm sure our panelists in the afternoon will have some takes. So property is exciting.
Well, I'm not sure how much more time we have.
Probably none.
Yeah, I think we might have run our time. I'd like to take one question from, or one or two questions from students, if anybody has one. Looking at the back row.
Joe.
So I guess since we finished on the space side of it, I mean, my question is basically, in the development of property rights in space, and basically try to come up with kind of like some sort of like at least a minimum standard. What do you think is gonna? Do you think they're gonna recognize the private right to property? Because right now the Outer Space Treaty doesn't consider private entities. The other treaties also don't consider them. It's all based on some sort of national jurisdiction. So what do you think will be the best solution into like bringing the private entities into this?
Well, we do have actually some international space law in the context of ownership of space vehicles. So there's quite a, I think, a well-established concept about ownership of space vehicles. And space vehicles are defined to include not only spacecraft, but also anything contained in the spacecraft. So if we're thinking about taking modules up to a celestial body, the ownership of those modules, the parts brought from Earth, are already pretty well defined. So that part we know. The variables are this notion of, can outer space be owned, or can part of the moon or the celestial body be owned? And I think most people would say no, they're not subject to private ownership, and we can talk about that later in the afternoon. The interim stuff, I think, is mining rights, which in civil law terms we might consider a usufruct, or in U.S. terms we might consider a profit or maybe a lease. I think that's a really interesting area. I think most people would say probably there's nothing in the international scheme that prevents a nation from mining on a celestial body, and that's an issue that's coming very, very quickly. Beyond that, it's the question of satellite orbits, and that's a really interesting area. We got law on that. The International Telecommunication Union allocates satellite orbits, and initially satellites, as you probably know, were mainly governmental. So it was the ITU deciding which government got slots, but increasingly private business had taken over that world, and so you've got privately owned satellites which are operating in orbital slots allocated in international law by the ITU. To me, that's an example of international law creating property rights, just like deep sea minerals. So back to your question, I think the notion is territorial rights. I, for one, agree with those who think that there can be private property rights in space in a limited sense, in the sense of, at a minimum, each nation under the Outer Space Treaty of 67 is allowed to have stations. And this is based on the Antarctica Treaty. As you may know, in Antarctica, we have stations. We're allowed to have stations. McMurdo Station in the summer has over 1,000 people. It's a U.S. station. It's a small town, folks. There are 1,000 people who live there in the summer. It's a station. The Antarctica Treaty allows stations. We can have lots of stations in Antarctica if we chose to. And the Chileans have some stations. They actually have some private businesses on their stations. They have a hotel, they have a bank, purposefully to try to establish a territorial claim. So have a claim. They're one of the claimant states. But if we can have a station, say the U.S. can have a station on the moon, the question becomes, well, could the U.S. not lease out part of that station to private entities? Or create some kind of 99-year lease or long-term, not title, but some kind of property-like right, like a Chinese land use right? And I think the answer is sure. Yeah, I don't think there's anything that precludes that as a matter of international law. So from that, at that dimension, yeah, maybe. that we could have a property-like right, and frankly, I think it's probably likely at some point. So we have to distinguish between objects that go into space and then orbital rights, and then kind of physical rights to the surface, or more likely the subsurface of a celestial body. So these are exciting issues, and we have kind of the same tension here in a way that we've had with so many other natural resources, the global commons, be them deep sea modules or genetic resources or biodiversity resources, between developed states and developing states. And this whole issue of, is it legitimate for Germany to send a robot up to the moon to mine, or would Germany or the German entity have to share the proceeds of that mining with all nations in the world under the Outer Space Treaty of 1967? So those are the issues we'll be confronting, and I know our panelists this afternoon will have some opinions on them. But it's exciting stuff. Yeah.
And I think that's about all the time we have, so we should get into the next panel. But